Good afternoon, everybody. Welcome to our webinar. I'm Tim Johnson. I head the Field Fisher Media Practice, and I'm joined by Alisa Logvinenko, who is my colleague on the media team here. Usually in the early part of the year, we organise what we call a media crammer, which is an in-person seminar where we try and deliver a lot of information crammed into short periods of time over a variety of topics. We normally do it during the course of a morning. This year, for obvious reasons, we've decided to do it virtually over the interweb and also to break it up. So this is the first of a series of media crammers, but we're going to adopt the same format, which is we are going to throw a number of different topics at you around the media industry might look like post-Brexit. They're going to be short and sharp, so they're not massively detailed essays on any particular subject, but hopefully they'll provide you with information that will be useful for you. Before we actually get into the substance of today's seminar, I should mention that there is a development today which is related. It's not exactly on the subject of media post-Brexit, but there has been an opinion published by the Attorney General of the European Union in the Canal Plus case. And it might be relevant, well, it will be relevant when that case comes to a final judgment to all of us in the media sector. So it might be worth you trying to look at that. Yes, in English yet. Basically, the European Union ever since I've been practicing law, which is the interrelationship between copyright on the one hand, which is essentially a kind of monopolistic right, and competition law on the other hand, which basically wants to break down monopolies. And the European Union has been struggling with this for a long time. In 2016, a competition inquiry into the practices of the US studio settling against commitments given by the US to, if you like, relax some of their territorial restrictions. Canal Plus challenged that because they said that that then impacted their ability to do business. And this is the case that's being heard at the moment. On the face of it, it's quite a technical point, which is that the European Union didn't take it, or the European Commission didn't take into account the interests of or the impacts that their decision might have on people. But actually, when we see the judgment ultimately, although the Attorney General's opinion doesn't apparently deal with the issue of territorial licensing and the impact that may have on film financing, I think that probably this judgment will be an important one for us all to bear in mind when we look at the practice of territorial licensing for copyright assets. Anyway, having said that, and apologies for that slight digression, but it is hot news, hot off the press this morning. If we have the next slide. The substance of today is just to highlight a few things that we think are going to be impacted. At the moment, there isn't a great deal of talk of Brexit because all of the talk is about COVID-19, but we shouldn't forget the fact that Brexit is going on. We have left the European Union. We're in a transition period that will carry on until the end of the year. At the moment, there's no indication that that transition period is going to be extended. I imagine all of us on this seminar will have a view as to what the right solution to that might be. But for the time being, we're in a transition period that ends at the end of the year. And at the end of that, in the Brexit scenario, the relationship of the UK with the European Union in the media sector will be changed. And we're going to look today very briefly at how cross-border copyright clearance might be affected, in particular the country of origin principle in satellite broadcasts and the Portability Directive. Cross-border licensing, that's licensing of broadcast services. And then issues around digital copyright, the amendment to the Audiovisual Media Services Directive, and some issues in relation to satellite decoders and online harm. So with that, I'm going to pass over to Alisa for the first part of that. And if we can have the next slide, please.
So the first point of discussion in today's agenda is, as Tim said, the potential effect of Brexit on the satellite broadcasting sector with respect to the additional cross-border copyright clearance that may or may not be required at the point of exit, this being the point at which the transition period ends and the UK fully and finally leaves the EU, which is currently set to be the 31st of December 2020. So starting with the pre-Brexit position, as you know, to date, UK and wider EU satellite broadcasters alike have enjoyed the benefit of the Satellite and Cable Directive, which has coordinated the rules around copyright clearance for satellite broadcasting and retransmission within the EU. The key benefits of the directive hinged on the country of origin principle, which pre-Brexit has meant a single point of clearance for all EU members alike. For the broadcasting sector, this was achieved by way of a legal fiction whereby the uplink station, i.e. the place of transmission of program carrying signals to satellite, was treated as the place from which the communication is made, and not at the place at which those program carrying signals are received. In effect, this has meant that in the event of any broadcast, only a single active communication would be deemed to take place, and it would be deemed to take place in its country of origin. Consequently, this has meant no additional copyright clearance was then required between transmitters, i.e. broadcasters, and receivers, i.e. users, in cases where transmitters and receivers are located in different EU countries. However, this is set to change following Britain's exit from the EU. Turning to the post-Brexit position, on exit, the UK will no longer be part of the European Economic Area, so won't fall within the scope of the Satellite and Cable Directive, and so additional clearance for transmission from the UK into the EEA countries will be required. This means that this legal fiction will cease to apply, but only when it comes to UK broadcasters wishing to broadcast into the EEA. By contrast, the Copyright Designs and Patents Act 1988, which incorporates the Satellite and Cable Directive into UK law, is not set to change or be revised. So UK broadcasters wishing to broadcast into the EEA will have to clear additional rights, unlike EEA broadcasters into the UK, or in respect of broadcast from any remaining EU member state into another. So clearly there's a disparity there, and whether it'll be possible to achieve an amendment to the Satellite and Cable Directive to allow for the UK to be caught within its scope, despite its non-member status, remains to be seen. Hopefully the UK showing willing in its home legislation will be a start. Turning to the next slide. There we go.
Right, so and I should say, just before I get to portability, in my excitement to tell you the Attorney General's opinion that was published today, I want to mention that you're most welcome to ask questions of us as we go along. There should be a little box where you can type your question in, and that will come up on my screen. And what we will do is, when we've got through the main substance of the seminar, if there are any questions, I'll run through them and we'll try and answer as many of them as possible. And in some cases, I've done these webinars before, some of those questions, the same issue is raised by a couple of people. What I'll do is try and consolidate them into one. So please do feel free to avail yourselves of that. So anyway, turning back to this slide, the Portability Regulation. So for a long time, regulators in the EU couldn't understand why people who subscribed to audiovisual services in one member state couldn't then, when they went on holiday, traveled on business, get access to those services when they went to another country. Now, obviously, as copyright lawyers, we would say that's because it would copyrightorial licensing in copyright. So the EU eventually brought into effect a portability regulation, and what it said was that subscribers to services in one EU member state must be free. The service provider must allow them to access that service if they travel to another member state. And they addressed the issue of the copyright issue by effectively creating a legal fiction, which is that the copyright infringement, or the copyright infringing act, the communication to the public, was deemed to occur not in the country where the person was visiting, but in the country where they came from. In other words, in the country where they originally subscribed to the service. So in other words, if I subscribe to a service in the UK and I go to France on holiday and I watch a film or a TV program on that service in France, for legal purposes under the portability regulation, I am deemed to have done that in the UK, and so there is no copyright infringement. Now, post-Brexit, I'm afraid the UK will stop benefiting from this, because what the regulation says is, it says that for that copyright exclusion to work, the activity in one member state is deemed to be an activity in the member state from which the person has come. The UK will not be a member state, so the copyright fiction that they have created will stop working. It just won't work, and so services simply won't be able to allow portability unless they have cleared their rights on a multi-territory basis. And obviously there are some streaming platforms that do that. They won't be affected if you've got the right to provide material across the whole of the EU, then you'll be able to continue to do that and allow people to have access service wherever they may be. But if you are a provider of a service that is in one territory or a limited number of territories, then you won't be able to do this because the copyright, and there is no indication that either the EU is minded to change the law or the UK is minded to change the law. So I think the view that we are taking is that portability was a relatively short benefit. It actually came into force, I think, about 18 months ago. We should have enjoyed it whilst we could, but in the future, we won't be enjoying that portability any further. So now I'm going to pass back to Alisa for the next slide.
There you go. So we've now spoken about cross-border copyright clearance, both with respect to the Satellite and Cable Directive and the Portability Regulation. And now the third point of discussion is the potential effect of Brexit on cross-border licensing and what additional steps might need to be taken by the various stakeholders there. So again, starting with the pre-Brexit position, currently, and as will be the case until the end of the transition period, the EU broadcasting sector enjoys an integrated licensing framework. Again, the framework is based on the country of origin principle, whereby, in this case, a license obtained and regulatory standards observed in one state are sufficient for an audiovisual media service provider to offer its services in another state without further authorization. So an AVMS service provider being either a satellite broadcaster or an on-demand and non-linear audiovisual platform. Now, the directive language specifically is that member states should ensure the freedom of reception and will not restrict retransmission on their territory of services from other member states. So it's all about lifting that restriction. And so separately from copyright clearance, no further regulatory authorization or licensing arrangements are therefore required to broadcast into another member state. However, it's worth noting that countries, of course, remain free to require compliance with a more detailed or stricter set of rules from its own audiovisual media service providers, so providers established in their own jurisdiction. However, yet again, this leniency is set to change. So following Britain's exit from the EU, on exit, the UK will no longer be part of the EU, and so broadcasters in the UK will not have access to EU member states under this provision by virtue of EU membership, or vice versa. So in the UK, under the Broadcasting Amendment Regulations 2019, what will happen is that the key provision, Section 211 of Communications Act 2003, will be amended to require that any television services available in the UK be licensed by Ofcom regardless of its origin. So this means that for new licenses sought by EU broadcasters, a country of destination principle will now apply instead. And this will be the case, save for a few limited number of exceptions. So one of these being ECTT membership, which is the European Convention on Transfrontier Television of the Council of Europe, which will become more important post-Brexit. And the other point to note is that the government has confirmed that existing Ofcom licenses will not be revoked. So this will apply to new licenses only. In terms of the position in other EU countries and whether there'll be any leniency, UK broadcasters should of course ensure that the position in other states is monitored and assessed on a case-by-case basis, onerous as this may be. They should check whether there's an alternative regime they can rely on, for example, ECCT membership, or whether there are other ways to bring themselves within the purview of the pre-existing provision. So, for example, looking at provisions in Article 2, relying on satellite uplink or capacity provisions, noting that most EU broadcasting satellites are operated potentially elsewhere, and similar alternatives. So again, an incentive to reach a mutually beneficial reciprocity here. Another way definitely exists. And given the financial kind of the setup and framework of the benefits, both from UK broadcasters and international broadcasters alike, both would certainly benefit. So moving on to the next point of conversation, and changing the slide to the amendment slide. There we go.
So thank you, Alisa. So now let's talk a little bit about what changes to UK law might still happen as a result of our being in this transition period. So obviously most of you will know the way European Union law works is that when the European Union wants to homogenize law and make sure that law is consistent across all of its member states, it issues a directive. And as Alisa said in the previous presentation, usually the directive says you must implement in your own country laws that meet these minimum requirements. Usually member states are free to impose other requirements, but generally speaking. So, and there are two directives which could be affected. They have been amended at the European Union level, and they are due to be implemented. One is due to be implemented this year before the end of 2020, and the other is due to be implemented by next year. In the various member states. The first is the Audiovisual Media Services Directive, which way back when was called the Television Without Frontiers Directive. And this is the directive that basically, as Alisa said, it imposes minimum requirements on the licensing of television services or broadcast services in each member state. And then it says that provided that all of the member states have done that, then a television broadcast from one member state should be freely available in other member states. Originally, it applied to television. They then amended the directive so that it covered any kind of audiovisual service where the person running the audiovisual service had editorial control. And then most recently, they have introduced an amendment whereby they want to extend the scope of the directive to cover certain video sharing platforms. Platforms, obviously, the video shares do not have editorial control over their content. So they've introduced an amendment which has to be implemented in the various member states by the end of this year. And as we're in the transition period and the UK is still bound to keep its laws until the end of this year aligned with the European Union, then the UK should introduce this amendment. And it will require video sharing platforms to meet certain minimum standards. And you may well ask what a video sharing platform is defined as. The directive says, and I'm going to look across to my other screen to get the language exactly. A sharing platform is a service where the principal purpose of the service or of a dissociable section thereof or an essential functionality of the service is devoted to providing programs, user-generated videos, or both to the general public, etc., etc. Now, we're not quite sure what that means, if I'm honest with you. The European Union is supposed to be providing guidance as to what that means, but has not done so yet, possibly because they're also wrestling with what the concept of dissociable section or essential functionality is. So I think we will have to watch this space and pay attention to how this amendment is actually implemented in order to understand exactly what video sharing platforms, or indeed what elements of a video sharing platform will be captured. The other thing in relation to the Audiovisual Media Services Directive, which doesn't relate to an amendment to the directive, but one of the requirements of the Audiovisual Media Services Directive is that television broadcasts or television providers should include a minimum amount of European content, so content that originates from Europe. People have been concerned over the last, well, actually since the Brexit vote, as to whether programming that originates in the United Kingdom will continue to be European for the purpose of these quotas. Now, actually, it will continue to be European by virtue of these quotas, because the Audiovisual Media Services Directive refers to programming that originates from a member state, which the United Kingdom will cease to be, or a country that is a party to the Council of Europe Convention on Transfrontier Television, which is a separate convention that goes beyond the European Union, and the UK has no plans to cease to be a party to that convention. So as productions UK party to the of the AVMS, the Audiovisual Media Services quotas. Now, the other directive amendment, which is coming up, which needs to be implemented by member states, is the Digital Copyright Directive. And that is obviously a directive which requires member states to align their laws in relation to certain issues in relation to copyright. And there are a couple that are there are a couple of issues which the European Union has focused on, which are in this directive. One of them, which has been quite controversial, is the implementation of a bestseller provision, which broadly is a provision which requires member states to have a law that allows authors to benefit if a copyright work does really, really well. And obviously there are different views as to how beneficial that is. Users of copyright materials aren't that keen about it. People who create copyright materials are keen about it. But in any event, it is there. Actually, as it turns out, the UK government will not be bound to implement the terms of this directive because the implementation date goes beyond the end of this year, although obviously if our transition period were to be extended, then we would have to keep our laws in the UK in line with the European Union for longer. But as of today, the implementation date is after the end of 2020, so the UK government is not bound to implement its terms. But the UK government may choose to do so because it may come to the view that there is a benefit to continuing alignment between the United Kingdom and the European Union copyright regimes. So again, this is a watch this space topic. So with that, I'm going to ask for the next slide to be put up and to pass back to Alisa to deal with the last couple of topics that we have to discuss today.
Okay, so just as a roundup, really, and a couple of other topics that are interesting, in which there have been developments and which are relevant to your space. So in respect to the first, which is satellite decoders. So again, the pre-Brexit position is different from what we expect to happen post-Brexit. So historically, the position in relation to the use in the UK of UK satellite decoders hasn't been clear. So UK satellite decoders lawfully obtained in other EU states, whether they were able to be used in relation to UK broadcaster content, especially whenever, for example, non-payment of BBC license fees and events. In the run-up to the general election, for example, there was a good deal of speculation that BBC non-payment of BBC license fees might be decriminalised. So, you know, in the 2011 Murphy case was also not helping clarify the position. However, now that post-Brexit, the UK government will be free to implement whatever legislation it sees fit in relation to satellite decoders. The government has actually indicated that it will amend existing legislation, such as to make it an offence after the UK leaves the EU to use a satellite broadcaster decoder device intended for an EU audience to access a programme included in a broadcast made from the UK to avoid payment. So this would, of course, put an end to any perceived legal loophole around this issue, where people have avoided paying for UK satellite subscriptions by obtaining satellite decoder cards through subscriptions in other EU countries. Final points to note on online uses and the government guidance which has been issued around this. So online harm, which is a key area of interest for Theresa May's government, and commentary in white papers published historically has indicated that they were very interested on developing and improving internet safety for all. However, since then, there is an indication that the new government may take a less aggressive regulatory approach than might have been anticipated previously, saying that the government want to keep people safe online, but that they want to do this in a proportionate way, ensuring that freedom of expression is upheld and promoted online, and that the value of a free and independent press is preserved. So balancing the need to protect internet users with freedom of expression and the need to preserve that. And finally, on online newspapers, which has been sort of the VAT chargeable around online copies of newspapers, having been a thorn in the side of the news sector for some time, this is now set to be clarified in that following the initial first-tier tribunal decision, which ruled that digital editions were not exempt from VAT and that VAT was therefore chargeable, the news sector will be heartened to hear that the upper tribunal decision in News Corp versus Revenue has ruled that digital editions of certain newspapers are in fact newspapers under VAT legislation and therefore are not subject to VAT, as they should be zero rated for VAT purposes. So some good news there. And now I think we're passing back over to Tim for chairing the Q&A.
Yes, thank you, Alisa. Now is your opportunity, if you've got any pressing questions, to type them in. One question that we have relates to the discussion about licensing of satellite broadcast services. The question is, if the UK remains a member of the Convention on Transfrontier Television, which covers all of the states that are signatories to that, couldn't you continue to rely on that instead of the Audiovisual Media Services Directive in terms of licensing your broadcast service out of the UK? I think the answer to that, and Alisa will correct me if I'm wrong, the answer to that is that first of all, not every EU member state is in fact a signatory to the Council of Europe Convention, so there is a mismatch in if you like, the territorial coverage of the two things. And the other thing is that the Audiovisual Media Services Directive has developed quite dramatically in the last 30 years. It was originally introduced in 1989 as the Television Without Frontiers Directive. The European Council Transfrontier Television Convention was introduced, I think, in 1990. So quite a long time has passed. Obviously, the Audiovisual Media Services Directive has developed in a much more depth by virtue of first of all being reissued as the Audiovisual Media Services Directive and then being amended in the way that we've discussed today. So I think whilst technically you can rely on the Transfrontier Television Convention, I suspect that most people will be looking at continuing to have the benefit of the Audiovisual Media Services Directive as well. So that is one question that's come up. I'm looking to see not very many people are typing, so I'm just checking that nobody's typing. No, nobody's typing at the moment. So we did promise that this would be short and sharp. We would aim to complete it within 30 minutes, which is what we normally do for each of the topics when we do the Crammer in person. So it just leaves me to say thank you very much for attending, for listening to us. If you do have any questions after this, when you look through the slides, or if anything comes to you, you are most welcome to get in touch with us. You know where we are. And please also feel free to sign up to the next seminar, or the next webinar in the series, in the Media Crammer series, which will be happening in a few weeks' time. Unfortunately, when you register, you only register for one at a time. So you actually have to register for each webinar separately. That's to do with the functionality of the webinar software. But please feel free to do so. And if you do, we will look forward to having our colleagues present to you on other topics later on during the year. So thank you for your time. Thank you for attending. It's a shame I can't see you all too, but I will wave to you and say have a very good afternoon and a very good bank holiday weekend. Thank you.